Hello, everyone. Thank you for joining us for this latest Fox Williams webinar. And the purpose of this webinar is just to take you through all of the regulatory reforms which are happening at the moment, because there are lots. I mean, there's a lot going on. There's a lot that we've spoken about previously, or we've published articles and sent updates to our clients. And we just thought that this would be a convenient opportunity to bring it all together in an hour's webinar just to make sure that everyone is aware of what's happening. We have quite an ambitious agenda, I would say. If we can just skip to the next slides, please, Dan. Um, and The plan is that we're going to try and zoom through all of these over the next hour. And this session is being recorded. Nobody can see you because the cameras are off. But we will circulate copies of these slides after this session. The first agenda item of today is the new consumer enforcement powers. Now, you may already have heard about these, but on the 6th of April of this year, the regulators in the UK were given a slew of new powers to enforce consumer and travel law in the UK. And the purpose of these powers is really to bring compliance with general consumer law and with travel law up to the standards of compliance with something like GDPR or compliance with sort of competition law. Because previously it's been thought that the UK enforcement of consumer law and travel law just wasn't rigorous enough, and the tools that regulators have to enforce consumer laws just weren't fit for the job. So that's all now changed with the introduction of the new Digital Markets Competition and Consumers Act, the DMCC, which has been a long time coming, but it's now in force as of the 6th of April 2025. Now, primarily, these new powers give the Competition and Markets Authority powers to decide for itself whether there has been a breach of consumer or travel law, and then to set sanctions for non-compliance that they have seen. Now, previously, if the CMA wanted to bring enforcement action, they would actually have to take somebody to court, and then there would be a long court process leading eventually to a judge having to make a decision. Now, that was very long-winded, very time-consuming. I think that the CAA have had experience of that, of a case which took about 2 years to come to trial, involving a low-cost airline. So the plan is, with these new changes, is to give the CMA the power just to decide for itself that there's been a breach. In the same way that the ICO, the Information Commissioner's Office, can decide for itself whether there's been a breach of data privacy law and impose fines accordingly. So that's all quite new. It's going to short circuit the process. The CMA have said that they are going to look to use these powers swiftly. So they do actually have a duty of expedition under this new law, which means that they have to progress things really quickly. So when they do decide to bring enforcement action, they will move things forward really, really quickly. And as well as deciding for itself whether there has been a breach of, let's say, the package travel regulations, they can also then decide what sanctions to impose. And this is probably the biggest sea change in enforcement of consumer law. They are going to have the powers for the very first time to impose fines for non-compliance with consumer and travel law. And those fines are going to be huge. The starting point for any fine, and they've recently published guidance about this, is between 7.5% and 30% of UK turnover. So where you are on that scale will depend on how serious the breach of consumer law is. So 7.5% of UK turnover will be the starting point for less serious breaches of consumer law, whereas 30% will be the starting point for the most egregious breaches of consumer law. So That's obviously extremely significant, and is really designed to try to make enforcement with consumer and travel law a serious an issue for businesses as is compliance with data or competition law. Those fines are subject to a cap of 10% of worldwide turnover. So um, having started with the starting point and having considered whether there are any aggravating or mitigating factors, there is this ultimate cap. So if the fine that's been calculated based on your UK turnover exceeds 10% of your worldwide turnover, then the fine will be brought down so that it's capped at the 10% worldwide turnover figure. There's also the possibility of directors or senior managers being fined, and that's up to £300,000. And the other thing to understand about these developments is that the CAA is also getting new powers, and they're getting these fining powers. So the CAA, unlike the CMA, can't decide for itself whether there's been a breach of consumer law. The CAA would have to go to court and to persuade a judge that there has been a breach of consumer law. But if they are able to do that, then they will be able to ask the judge to impose a fine. And this is a new power for them. They haven't had this power before, and the level of those fines are the same as what I've already described for the CMA. So, what do you need to do to make sure that you're not going to fall foul of these new rules? Well, make sure that you're complying with consumer and travel law. And I've listed on the slide here various areas which the CMA has identified as being the areas that they're most interested in at this point. So after an initial 2-month bed-in period, um, you know, the CMA will start to look to use these new powers. And for travel industry clients, the areas that I've identified in the table here are those that you need to be most concerned about. So make sure that you're not falling foul of any of the rules in relation to those matters. So that's me. I'm going to hand over to Samira now to talk about fake reviews.
Thank you very much, Reese. So the DMCCA has also updated the unfair commercial practices regime in the UK, setting out 2 new banned practices which are automatically unfair and illegal. The first of these banned practices relates to fake reviews. The diagram on the slide is an extract from the CMA's guidance on this. Taking each of the elements in turn, the first thing to note is that the banned practice relates to consumer reviews and consumer review information. A consumer review is defined broadly by the CMA and includes any matter relevant to a transactional decision. Consumer review information is information derived from consumer reviews, such as overall ratings, review counts, and rankings. Next, the banned practice prevents the submission, commission, and publication of fake reviews and concealed incentivized reviews. Together, these are banned reviews. A fake review is a review that is not based on a person's genuine experience. And a review conceals the fact that it has been incentivized if a person has been commissioned, whether by money, discounts, or freebies, to provide the review, and that fact is not made apparent. So companies are still free to incentivize reviews, but they must tell consumers that the review is being incentivized. The banned practice also requires companies not to publish consumer reviews and consumer review information in a misleading way. This includes, for example, failing to publish or removing from publication negative reviews whilst publishing positive ones, or giving greater prominence to positive reviews over negative ones, or vice versa. Finally, companies publishing reviews must also take steps to prevent the publication of banned reviews, as well as false or misleading review information. Next slide, please, Dan. The CMA has stated that all publishers will need to have a clear policy on the prevention and removal of banned reviews and false or misleading review information, assess the risks of such information appearing on their website, and take further proactive steps to address the issues identified. This element of the banned practice creates a positive obligation. However, companies will need to be careful to screen suspicious activity without preventing genuinely lawful reviews from being displayed. We have published a separate article advising travel companies on the practical steps they can take going forwards. Following on from feedback that the new law will require changes to systems and compliance programs, the CMA has allowed a grace period until the 6th of July for compliance. Until that time, the CMA will focus on helping businesses comply with the new rules rather than on sanctioning non-compliance. The second of the new ban practices relates to drip pricing. This is the practice of showing consumers an initial headline price for a product and subsequently introducing additional mandatory charges as consumers proceed with the purchase. The new rules will require that any invitation to purchase, which broadly means any advert which mentions the price, must feature a total price which includes any non-optional charges. If these can't be calculated in advance, information about them and how they will be calculated must be given equal prominence with the total price. Examples of non-optional charges include booking fees and local taxes. When companies wish to offer optional services, these do not have to be included in the headline price if they are genuinely optional. However, the invitation to purchase will still need to include the cost of those additional services, or where they can't be calculated in advance, the fact that they may be payable. It is important to note that any product listing on a website will likely be an invitation to purchase, and consumers may be presented with an invitation to purchase at multiple points during the booking journey. The CMA has stated that pending its further guidance on drip pricing during the autumn, it will only take action against genuinely unexpected mandatory charges added on at the end of the purchasing journey. We therefore recommend that travel companies carry out an audit of their customer booking journey as soon as possible. I'll now hand over to my colleagues Verena and Jess, who are going to discuss package travel.
Yes, so I'm here to talk to you about the consultation on the UK PTRs. In April, the Department for Business and Trade, the DBT, launched their second consultation on potential reforms to the PTRs. And you might recall they had an initial call for evidence back in 2023. So I've only got 5 minutes to talk to you about the consultation. So I'm just going to touch on the key proposals that the DBT is seeking feedback on. So number one is the right to redress. So the DBT is looking at making it easier for package organisers to exercise their rights under the PTRs to seek redress from third parties, so third party suppliers. So this issue was particularly highlighted during the pandemic, where where we had package organisers having to cancel and refund package holidays due to the cancellation of flights as a result of the pandemic, but then finding it really difficult to obtain refunds from those airlines. So that was one of the key issues and the key reasons behind this particular proposal. So the DBT is looking at clarifying this right of redress to make it easier for package organisers to recover refunds from third-party suppliers. And they give a few options. So for instance, the sort of main suggestion would be requiring suppliers to provide redress within sort of the specified period of time, potentially 14 days, in line with package organisers' timeline to make refunds to consumers. The second key proposal is around domestic packages. So the DBT is seeking feedback on removing UK only, so domestic packages from the scope of the PTRs, unless they include passenger transport. So essentially the type of package that they would be looking to exclude would be an example would be a UK hotel break that had a theatre ticket with it, so a UK theatre break where there's no transport included in that package. So potentially that could be outside the scope of the PTRs, and the DBT is seeking some feedback on that. The DBT is also looking at simplifying the definition of an LTA, and it's clear from the consultation that the DBT is open to ideas as to how this might be achieved. But the main option that they've mentioned in the consultation is scrapping LTA type A and LTA type B and instead having one single type of LTA which applies only to online sales. And it would look to capture a scenario where a customer makes separate purchases of different travel services from a travel company's website within a 24-hour window. So that potentially could be the only LTA going forward. The DBT is also seeking feedback on other tourist services, so potentially redefining when a combination of an other tourist service plus one other travel service, so whether that's transport, whether that's accommodation, sort of redefining when that would create a package holiday or an LTA. So currently, the other tourist service must be either an essential feature of the trip, or alternatively, it must amount to a significant proportion of the total value of the trip, which is typically considered to be 25% or more of the value of the combination. So the DBT is currently looking at abolishing the second part, so the significant proportion of the total value of the trip. So they're looking at sort of potentially removing that. So the only test then is whether the other tourist service is an essential feature. But the DBT is asking stakeholders whether this would provide more clarity. Now, in my opinion, I would say probably not, because that significant proportion part of the test is probably the only part of the test that is objective and provides a little bit of certainty. So that would be sort of my response on that, but you may disagree, and sort of this is your opportunity to provide that feedback to DBT. So looking at insolvency protection as well, so the DBT is seeking feedback on whether it should add more flexibility to the insolvency protection mechanisms for non-flight packages, and that's by allowing a combination of a trust account and a bond to be provided, and that would be in addition to the current option that we have under the PTRs of a combination of a bond plus insurance. So the DBT is also seeking proposals on other ways in which the cost of securing insolvency protection could be reduced for travel companies, but without reducing the protections that are available to consumers. So we would say that this is a really good opportunity to propose that some recognition needs to be provided for the fact that credit card issuers typically do pick up the costs of a failure, and they, most of the time they require security from travel companies to protect against that risk. So there is already, there is an element of double protecting a customer's booking, and we think this is a really great opportunity to be able to sort of feed that back to the DBT, and certainly in any responses that we've been providing or we've been preparing for clients, we have flagged that as a key issue. And then lastly, the DBT is looking at the location of insurance providers. So currently the providers of financial failure insurance must be authorised in either the UK, the Channel Islands or the Isle of Man. The DBT is looking at or considering whether to relax the territorial restrictions in order to allow more insurers to come into the market, and is sort of seeking feedback on whether that would be beneficial for travel companies, and also what the risks and what the challenges would be in relation to that. So the consultation is open until the end of this month, so until the 30th of June. So that's a deadline for your responses. Reece did actually attend a DBT roundtable on Monday, and sort of the feedback that sort of he's given from that meeting is that the DBT is genuinely considering the feedback that it is receiving from the travel sector. So this is a really good opportunity if you do have any strong opinions or responses in relation to these proposals. It's a really great opportunity to be able to feed that back to the DBT. So please do take advantage of the opportunity. We'd be obviously happy to help with any responses, but even if you don't need our help, please do send in your responses to us as well, because we would be really interested in sort of hearing about everybody's responses to the consultation. So on that note, I will hand over to Jess, who's going to be looking at PTD reform.
Hi, everyone. So I'll be giving a quick overview about the key proposals in the EU Package Travel Directive reform. And like the UK, EU lawmakers are reviewing package travel to strengthen consumer protections and to clarify the existing regulations. And the pandemic, and along with the failure of some major travel companies, such as Thomas Cook, highlighted serious gaps in consumer protection. So as a brief reminder about the timeline, in 2023, the European Commission undertook a formal review and published its proposed reforms. In December 24, the European Council adopted its negotiating mandate, also called the General Approach, which allows the Council to begin talks with the European Parliament. The European Parliament is expected to vote on amendments by mid-2025, so we should be hearing something any day now. And then these proposed reforms will undergo negotiation before final adoption likely to be in early 2026. And once the final text is adopted, there will be a transition period, typically between 12 and 24 months, where EU member states will then have to implement the new rules into national law. As Farina mentioned, we're limited for time, so I'm not going to run through all of the proposals, but we'll just mention the ones listed on the slide. So similar to the PTR reform, one of the key areas is the clarification and expansion of what constitutes a package. Under the proposed amendments, a booking will qualify as a package if it includes multiple travel services and involves the transfer of the traveller's personal data between traders. Whereas under the current regime, these types of linked bookings would instead likely fall under the definition of LTAs. New timing thresholds may also be introduced. For example, if a traveller books different travel services for the same trip within 3 hours, this will be treated as a package under the proposed reforms. Similarly, if a trader invites a traveller to book additional travel services before the first booking is complete, or if further bookings occur within 24 hours of the original contract, this will also be treated as a package. And the EU goes further than the UK because this expanded definition effectively absorbs the concept of LTAs, which hopefully intends to simplify the framework. And for any situations that don't meet the revised definition, the reform imposes a duty on traders to clearly inform customers when they are not protected under the PTD. So moving on to prepayments, under the current PTD, there are no rules on how much an organizer can require upfront. It's entirely up to the organizer to decide on both the amount and the timing of prepayments. The European Commission has proposed a limit of 25% of the total price on prepayments at the time of the booking, except for packages booked less than 28 days before their start. However, some flexibility is built in. And if an organizer has to pay more than 25% to a supplier, for example, if an airline demands 35% upfront, then that organizer is allowed to pass on that cost and request a larger deposit from the customer. The European Council and Parliament have both expressed concerns about this proposal, and the European Parliament has suggested going further and introducing trust accounts which would hold and safeguard customer prepayments until the package begins. With vouchers, the pandemic exposed major shortcomings in how refunds were handled when trips were cancelled, with many organisers issuing vouchers in place of cash refunds, often without a clear legal basis or consumer consent. And the reform aims to codify and standardise voucher use to offer clarity and enhance consumer trust. So under the proposed changes, vouchers may be offered as an alternative to a cash refund, but they must not be mandatory. So travellers must always be able to request cash if they prefer. They must also be valid for 12 months, which could be extended by written agreement. And then the European Parliament has also proposed that vouchers should be transferable to another person once free of charge. And once the 12-month validity period expires, a cash refund must be paid out automatically without the consumer needing to submit a request. And finally, refund and redress, which Farina mentioned earlier. So under the proposed amendments, tour operators would be entitled to claim refunds from suppliers within 7 days of cancellation. So this change is designed to support organisers in fulfilling their obligation to refund customers within 14 days under the PTD. And while the proposal establishes the 7-day refund right, it does not specify how this would be enforced. So organisers may need to rely on contractual agreements to ensure compliance from suppliers. And we'll continue to monitor developments closely. So keep an eye out for any articles or briefings that we might publish on this topic. And I'll now hand over to Rhys to talk about the Online Safety Act.
Thanks, Jess. Online Safety Act. What does this have to do with travel? You have probably seen this mentioned in the news. It's been quite controversial. It's the UK government's attempts to make the internet safer, particularly tackling, some of the harms that can occur, particularly with children using social media and other sort of user-to-user platforms. So that is the main target for the Online Safety Act. However, it does have a broader application to that, and it does apply to a whole bunch of different operators within the travel industry, depending on what they do. There are two types of regulated activity which to my mind, are capable of capturing travel companies. And both of these, will apply to online services. And I'm going to use websites as an example here, but it would apply equally to apps or any other sort of online facility. So there are two types of regulated activity which I think travel companies need to know about. The first one is if they operate a search service. Now, what this means is, if your website has a search tool on it, which draws information from third-party websites or databases, then you are going to be caught by the Online Safety Act because you are operating a search service. Now, interestingly enough, Ofcom, which is the regulator of the OSA, published some guidance just before Easter, describing that one of the way in which information may be drawn to a website is through API connections between, the website and third-party databases. Now, this is obviously something which is quite common in the travel industry, with online travel agents having a search box which draws information from third-party airlines or flight aggregators or bed banks through API connections. So Ofcom think that that sort of thing will be a search service and therefore is captured by the Online Safety Act. And they actually give us as an example, although slightly different from an online travel agent, Skyscanner. So Skyscanner was identified very early on in the OSA process as being, an example of a search service because they have a search tool which enables users to search for flights, and that search tool or the website ultimately gets its information through API connections with third-party websites or databases. So that's going to capture lots of websites and how they operate in the travel industry. The other kind of regulated activity under the OSA, which is going to be relevant to travel companies, is if you're providing a user-to-user service. Now, the way this is defined is it's basically any aspect of the website which allows one user of the website to kind of upload information or upload content, and that could be, words, pictures, whatever, and then for another user of the website to encounter that. Now, before you think that this is just designed to capture things like X, it's much broader than that, and it does potentially capture travel companies. For instance, if you are hosting reviews by customers, or if customers can post reviews onto your platform, which other customers can see, then that's likely to be an example of a user-to-user service. Similarly, if your platform allows different users to interact with themselves, so for instance, if a customer and a hotelier can communicate with themselves through your platform, then that's another example of a user-to-user service. And finally, if you're operating a platform type model, so maybe not so much an online travel agent, but an Airbnb type model, which allows users to create and upload accommodation listings for other users to book, then that's another example of a user-to-user service. So travel companies, the point I'm making is that travel companies need to think about whether they are within scope of one of these two types of regulated activities. If you are caught, what do you have to do? Well, the main thing is to carry out a risk assessment to understand how users of your website may be harmed through using your website in some way. And what that means is that you need to sort of apply your mind to the risk of one of 17 different criminal offences which are listed in the Act. So what's the risk of one of those taking place on your platform or actually off your platform, and your platform is being used to facilitate the commission of that offence? In addition to those you have to consider those 17 specific criminal offences. You also have to consider criminal offences more generally. So what does that mean in practice for travel companies? Well, I imagine the sort of criminal offences that we're most likely to be concerned about is with things like fraud, or through use of the websites. But it could also be something more general than that. For instance, what's the risk of somebody uploading content which contravenes some criminal offence which somebody else may see, and also what's the risk of somebody using your platform to commit a criminal offence off it. Now, I would have thought, and the indications are that online travel agents are likely to be quite low risk. However, despite that kind of gut feel, there is still a positive obligation on you to carry out this risk assessment. And if you don't, then you won't be complying with the OSA. Having carried out that risk assessment, having thought about the risks and whether they're high, medium, or low, there is then an obligation to implement proportionate safety measures to manage those risks. So to the extent that you have identified a particular risk of fraud or some other harm occurring through use of your platform, then there is an obligation on you then to think about what steps you could take to address those risks and then to implement those which are proportionate. So there is an element of kind of reasonableness here in terms of what you have to do. And then, so that's the main thing, is the risk assessment. In addition to that, there are then some other, I'd say, more standard obligations on the website. So creating some sort of user reporting mechanism. So if somebody sees something they don't like, that they have a facility to be able to report that to you. And then there's also an obligation to set up some sort of complaints procedure. So if somebody makes a report and they don't have their report dealt with, or alternatively that somebody else's content is taken down because of a report, then if somebody wants to challenge that, there has to be some sort of mechanism which allows users to do that. So those are the main obligations. There's then sort of standard stuff about keeping records. When you're doing your risk assessments, you have to record that in writing. And you then have to, keep all of this stuff up to date. So there's an obligation to refresh your risk assessment from time to time. And then final one is you have a positive obligation to explain in your T's and C's or in an online statement what your approach is to compliance under the Online Safety Act. So that's it in general. I mean, all of this has very recently come into force. The Ofcom guidance has only just come out, so that's very interesting and adds a lot of colour to how this may operate in practice. But it is something that I suspect is probably flown under the radar in the travel industry, and it is something that, despite it, but possibly being low risk for travel clients, there are still these obligations to actually do something about it and apply your minds to the risk of harm suffered by users of your website. So that's it from me. So I think I'm going to hand over now to Jess again on the Accessibility Act.
So I will be giving a brief overview of the EU Accessibility Act, or the EAA, and we'll have a specific focus on its impact in the travel sector. So the EAA is an EU directive designed to ensure that people with long-term disabilities, including physical, mental, intellectual, or sensory impairments, can access key products and services on an equal basis with others. It came into force in 2019, with member states required to transpose it into national law by the 28th of June 2022. And the key date to remember is the 28th of June 2025, as this is when compliance becomes mandatory. So who is caught by the EAA? It applies to providers of certain products and services in the travel industry, including e-commerce websites and certain elements of passenger transport services, such as websites, mobile apps, electronic ticketing, the delivery of transport service information, and self-service ticketing machines. And that means that it will therefore catch most airlines, cruise companies, train companies, OTAs, and tour operators. And for the travel industry, this means a shift towards more inclusive digital experiences, more accessible ticketing, and real-time information that works for all passengers regardless of ability. There is an exemption for micro-enterprises offering services, which means businesses with fewer than 10 employees and less than 2 million euros in turnover, or an annual balance sheet not exceeding 2 million euros. And there are a couple of other exemptions, which I will mention shortly. And I should flag that the EAA has extraterritorial reach. So if a travel company offers services to EU-based customers, it must comply with the EAA regardless of where it is based. So how to comply with the EAA? So companies must take several practical and legal steps before the deadline of the 28th of June 2025. And the first step is to identify which services and products already meet the EAA accessibility requirements and which require remediation. An accessibility statement needs to be published on websites outlining how the products and services conform with the EAA and providing a mechanism for users to report any issues. If certain services do not yet comply, companies are required to inform the national authority in the relevant EU member state, and this must include a description of the non-compliance and the corrective measures being taken. Now, the EAA sets out the absolute minimum accessibility requirements that must be met across the EU for certain products and services, without further detailing how member states must comply with these. So member states are allowed to introduce stricter national accessibility standards if they choose. And additionally, the EAA specifies a range of products and services that must comply with the accessibility requirements. However, once again, member states can choose to extend these requirements to other products and services which are not explicitly currently covered by the EAA. So service providers must ensure that digital interfaces are perceivable, operable, understandable, and robust. And these four principles map closely to the Web Content Accessibility Guidelines, or WCAG. And there is a presumption of conformity such that if a company complies with the WCAG, they will be presumed to comply with the EAA. And just for a few examples of compliant accessible features, this includes text alternatives for images and icons, keyboard navigation support, captions for videos, high contrast modes, and assistive technology such as screen readers. And it's important to note that support and feedback channels must also be accessible. So as I mentioned, there is an exemption for micro enterprises, and there are also two further limited exemptions for businesses where compliance would be genuinely unworkable. So the first is fundamental alteration, and this applies when accessibility requirements would fundamentally change the nature or purpose of a product or service. For example, if adapting the service would compromise its core functionality, then the exemption may be relied upon, but this is an extremely narrow and high threshold to meet. And the second exemption is disproportionate burden. So this applies where the cost or effort required to ensure accessibility would be clearly excessive relative to the benefits. And when evaluating whether a requirement imposes a disproportionate burden, factors to consider include the size, resources, and nature of the business, the estimated costs of compliance, and the expected benefit to persons with disabilities. But importantly, any business claiming either exemption must formally document their assessment, and that may be subject to regulatory review. And then finally, in terms of the consequences of not complying with the EAA, enforcement is the responsibility of national authorities in each EU member state. So penalties may vary, but could include fines for non-compliance, withdrawal of non-compliant products or services from the market, and in extreme cases, certain individuals within the company could be imprisoned. So the EA is not just a compliance obligation, but it is part of the EU's broader commitment to accessibility and inclusion. And I will now hand over to Samira to talk about ATOL reform.
Thank you very much, Jess. So ATOL Standard Terms 1.3 and 5 are both terms of the ATOL with which every ATOL holder must comply. They have both been the subject of recent CAA consultations, and I'll discuss this for the next few minutes. AST 1.3 deals with information which ATOL holders must include in their adverts for ATOL-protected holidays. The CAA recognises that ATOL holders are now advertising their services through a variety of non-broadcast media, including digital platforms and social media channels. And at the same time, digital communication continues to grow. As a result, and as already discussed by Jess, accessibility is becoming a critical part of publishing digital content. With this in mind, the CAA has proposed to amend AST 1.3 so that it captures all forms of media advertising across all digital platforms, so not just TV, radio, and cinema. And any advert targeting UK customers that promotes an ATOL-protected trip contains the logo, number, and either written or spoken ATOL-protected message. The CAA has clarified in its draft guidance that the requirement only applies to adverts promoting ATOL-protected trips, and not aspirational travel adverts more generally. ATOL holders will therefore need to consider on a case-by-case basis whether the content of their advert significantly implies that an ATOL-protected service is being advertised. If these changes are implemented, affected ATOL holders will need to review all forms of media advertising, such as social media posts, determine how best to incorporate the information where space is limited, and train marketing teams and review their contracts with agencies and influencers to align with the new rules. Given the limited space on websites viewed on mobile phones and the bite-sized nature of social media posts, it may be difficult to incorporate all of the necessary ATOL language into adverts. We have prepared a previous briefing summarising the CAA's proposed approach to this. However, the consultation did close on the 14th of May. AST 5 deals with the business systems and booking information which ATOL holders are required to maintain. The CAA is proposing to amend AST 5 so that standard ATOL holders with an ATOL limit of £20 million or more must maintain additional booking data in a standardised format and provide this data to the CAA within 3 working days of a request. This is to allow the CAA to carry out ad hoc compliance checks, for example, to ensure ATOL holders are trading within their authorisation limits and are paying the right level of APC. It will also provide the CAA with the information they need to refund and repatriate customers on a failure. The new requirements have to be taken seriously. A reactive approach, for example, attempting to compile the necessary data only when a request is made, will not be viable given the short time frame for uploading the information. ATOL holders must therefore ensure that their systems and processes are structured to meet the CAA's requirements on short notice. If these changes are implemented, affected ATOL holders will need to ensure their systems can capture, store, and upload the required data in the specified format, review arrangements and contracts with IT system providers to ensure the services cover the new requirements, and plan for operational changes to ensure data can be provided promptly in the event of a CAA request. However, there will be a 12-month transition period from the date of publication of the amended ATOL standard term in the Official Record Series 3. We've also prepared a separate briefing on this. However, that consultation also closed on the 28th of February. I'll now hand over to Rhys to discuss the new failure to prevent fraud offence.
This is something we've written about before and have a fairly detailed briefing about on our website. But the law has been on the statute books for a while, but it's actually now coming into force on the 1st of September of this year. And it's a new criminal offence for corporates, which will make corporates liable for failing to prevent fraud by certain individuals within their business. And I'll come on to describe that in a bit more detail. The good news is for smaller companies is that this only applies to larger companies. So it will only apply to larger travel companies which satisfy any 2 of the three criteria I've got on the slides here. So designed to target big travel companies, and it will basically make it a criminal offence for the travel company if either an employee, an agent, so that would include a travel agent, or someone else that provides services for them, commits fraud with the intent to benefit the travel company. So I'll just unpackage that slightly. When I talk about fraud here, I mean, we're not just talking about stealing cash. It also includes things like, saying things which aren't true, knowing that they're not true. And that could be quite broad. It could apply to your discussions with the CAA or with another regulator. It could apply to discussions with bond obligors. So in those first two examples, and actually merchant acquirers as well, it would cover the sort of situation where an employee or somebody within the travel company isn't being completely truthful with the regulator or the merchant acquirer in order to secure a license or to secure an account or to secure a bond or something like that. So, I mean, that's how I see this sort of thing potentially applying to travel companies, but obviously it covers any sort of fraud, and fraud has a very broad definition. So anything like that which involves, half-truths or misleading third parties in order to benefit the travel company, will make the company criminally liable for it. And in a way, it's a strict liability offence. So that's going to be the case, even if directors or senior managers were unaware of what was going on at a more junior level within the travel company. So it's not going to save you if you say that some finance manager or financial controller got carried away in their discussions with acquirers or with the regulator, and there's an obligation, or rather, the liability will still sit with the travel company. Now there is a defence available, and that defence is basically a reasonable procedures defence. So whilst there is this strict liability on the travel company for acts of fraud committed by employees or agents, it will be a defence for the travel company to be able to show that they had reasonable fraud prevention procedures in place. And I mean, it's a bit like the Bribery Act that some of you may be familiar with, where there is a defence of having reasonable procedures in place to manage the risk of bribery within the company, and it's the same sort of thing here. So what that means in practice is, and the government has issued guidance on what those reasonable fraud prevention procedures should look like, and there is basically a process that has to go through where the travel company carries out a risk assessment, identifies where the risk of fraud is within the travel company, and then implements measures to manage and address those risks. So provided that you do have those anti-fraud measures in place and a written policy, documenting all of that with the usual things around training and within the organization, then that will give you a defense. So that is something that should probably be done if you are a large travel company, ideally before the 1st of September. And then in the event that there is fraud within the travel company which comes under the scrutiny of one of the regulators, then these reasonable fraud prevention measures would give you a defense. So that's it on that by way of quick summary. Like I said, there is a briefing on our website if you want more information, but I will now hand over to, I believe, Farina to talk about secret commissions.
Thanks, Therese. Yes, so I'm going to spend this last 5 minutes talking to you about a case law update in relation to secret commissions. So this is a case in the energy sector, and it's the case of Expert Tooling and Automation Limited and NG Power. It was a case that we received judgment on earlier this year, and the Court of Appeal looks at whether a broker, and just for context, the broker is a party called Utility Wise, and they weren't actually a party to these proceedings because they'd gone into administration. So the broker was acting as an agent on behalf of its client. So the client was the Expert Tooling, and Utility Wise as the broker were entering Expert Tooling into contracts with third-party suppliers for the provision of utilities. And this Court of Appeal case looked at whether the agent can retain commission it has received from third-party suppliers, where the existence of the commission has been disclosed to the client, but the amount of the commission has not been disclosed. And that is what is commonly known as a half-secret commission. So, as I mentioned, it's a case in the energy sector, but you'll see as I go through the facts and the judgment that it could have serious implications for travel businesses, especially travel management companies, so TMCs, if those TMCs receive commissions from their suppliers without disclosing the amount of that commission to their corporate clients. So in the original High Court case on this matter, it was held that although the broker did owe its client Expert Tooling fiduciary duties, the scope of the duty did not require the agent to disclose the amount of commission that it received or how that commission was structured. And the primary factors for that decision was around essentially the level of sophistication of the client, as well as sort of market expectation and relevant trade usage and trade customs. And it was found that this was something that was quite common in the energy sector. And the client was a sophisticated business. And so on that basis, it was found that the fiduciary duty didn't extend to disclosing the amount of the commission. The case was then appealed, and the Court of Appeal disagreed with the finding of the High Court. And so the Court of Appeal has concluded that an agent cannot lawfully retain a commission from a third party, such as a supplier, unless it has obtained the fully informed consent of its principal, i.e. the client. And fully informed consent in this context requires disclosing both the fact that commission is being received and the amount of the commission that is being received. So based on this particular ruling, that means half-secret commissions are potentially unlawful without full disclosure to the client. So basically, merely telling the client that a commission is received is not going to be sufficient. You would need to let the client know the amount and the nature of the commission, i.e. In this particular case, the commission was being added on to the rates that were then being charged to the client. So if you think of like a net rate with a markup, it was that kind of an arrangement. So, the Court of Appeal found that the nature of the commission arrangement also has to be disclosed. So this case has been appealed further. That further appeal is going to be heard in the Supreme Court. So we don't have a date for that yet. We are also awaiting the Supreme Court's judgment in the motor finance case. So that centres around car dealers. It's been quite a prominent case. You've probably heard about it, but it's where car dealers are acting as credit brokers, and they were receiving commissions from lenders for arranging vehicle finance for consumers. So those commissions were often undisclosed or only partially disclosed to consumers. So the case was actually heard in the Supreme Court in April of this year. We do expect to receive the ruling before the summer recess, so by the end of July. And it's likely that the outcome of that motor finance case will impact the further appeal of this equal tooling case. So that means that the position on this could change as a result of either the appeal on expert tooling or the judgment that we receive on the motor finance cases. But in relation to the latter, we shouldn't have too long to wait to be able to see what the outcome of that is. So as I said, although it's an energy sector case, although it has been appealed, we do think that it's quite important to have this on your radar if you are a business that operates in a similar way. So on that note, we're 1 minute over time, so I will bring that to a close, and I will hand back to Rhys.
I'm staggered that we've only run 1 minute over despite having so many topics, so that's great. Thank you everyone for joining. Like I said at the beginning, we will be circulating a recording, so to those that have registered, together with copies of the slides. We're also going to include in that links to articles about some of the topics we've been talking about today. I just want to flag one other thing as well, which our employment team are doing at the moment. There are, as you probably have seen, there are lots of employment law changes coming in the UK, and our employment team are holding a webinar on the 26th of June, and there's a link on our website. There's also a link in the slides, which is up on screen and which you'll get. They are also carrying out a survey, actually, which is looking at employment priorities in the tech space. And participants in that survey will receive some insights on that survey, once it's been processed and once they've received all of the submissions. So if you'd like to participate in that and receive the insights, then there's a link to a survey there, which you will get when we circulate these slides. Final thing from me is to say, we do hold these webinars 4 times a year. We are always interested in feedback and comments, but particularly if there are any topics facing the travel sector that you'd like us to talk about. So if there is anything like that, please do drop us a line. Otherwise, that's it from me. Thanks very much for bearing with us at the beginning, particularly with those problems with the slides, and I hope to see you at the next webinar.